Again, welcome everyone to today's webinar. We're focusing on an overview of the anti-hazing laws emerging at the state level. Our panel will be sharing what your organization needs to know and recommended action items. As we get started today, please type your name, organization, and the role you play into the chat panel. We'd love to welcome you. And with that, I'll turn things over to Dr. Lori Hart, Director of Educational Initiatives for Holmes Murphy, to set the stage for today's conversation.
Thank you, everyone. As people are coming in, I can't help but not look at Dr. Linda Langford as she pops in on the screen. Hello, Dr. Linda Langford. I think Linda has been in our space for me a presence of prevention and thought, and has really guided, I think, a lot of our career work that we do in the world of fraternity and sorority. So I say that to say, if you had said to me 10 years ago, well, what drives how we make decisions, or what we're doing in our spaces, or what we need to be doing, I think I would say, well, we should look at the social ecological model. Like, I never would have probably said 10 years ago, we should look at the state laws. But we started getting calls about these state laws several months ago, which kind of drives how and when we do webinars and what we do. And these 10 laws that we're going to talk about today are really going to impact who and how and what you do. I am forever grateful to Toby Evelyn, to Danny Weatherford, and to Clark Brown today. They are, from what I can see, they are the experts out there doing this work. And I want to really commend the NIC and NPC, not only for being here and being transparent with us to help all of our clients, but also in sharing some resources. So Toby, Danny, and Clark, for that, thank you. This is also, I think, our first panel where we have 3 attorneys talking to you today. So that's going to be fun. It's a lot of smarts and they're fun people. So I'm going to turn it over to them. There are no slides today, total conversation. Please use the chat function as you have questions. Take it away.
Okay, I'll kick us off. Thanks so much, Lori and Bobby. I'm really glad to see so many of you here today. We're excited to talk to you about a really important topic. I'll tell you first what we're not going to do, and that is we're not going to go state by state with all the states that have amended their anti-hazing laws in the last couple of years and read statutes to you. What we want to do instead is talk to you more about some of the themes that are prevailing throughout those laws, and some of the issues with those laws and how they're being implemented on the ground as a practical matter. So there are some great resources out there that provide the text of all of these laws. And it's really important that no matter which one you're dealing with, to actually go and pull the law itself, because each one has its own unique features. So with that, I want to start by telling you all how we accomplish this work on a week in, week out basis. The NIC and NPC are members, along with parents who have lost sons to hazing, of a coalition called the Anti-Hazing Coalition. The Anti-Hazing Coalition's website is antihazingcoalition.org. I'll drop that in the chat once I stop talking, but there is at the top of that page a link to our model legislation. And what the model legislation is really kind of the keystone of the coalition itself. We work with legislatures all over the country to implement as much of this law as they're willing to look at. And our advocacy is really focused on 3 primary points, although the model legislation itself is quite detailed. So one thing we always talk about with every legislature is increasing the criminal penalty for hazing that involves a bodily injury to a felony, about certain transparency and reporting requirements for institutions, and a safe harbor provision for those who are good actors and early reporters around hazing. So with that, I'm going to jump right in to an example of a law that's been updated here in the last couple of years. We're really proud of this one because the state of New Jersey, the Timothy Piazza law, is really one of the first instances in which a state legislature has taken the model legislation and almost adopted it in full. So you'll see in the New Jersey legislation and the New Jersey law, a really detailed and thorough definition of hazing. You'll see an increased that definition, the New Jersey hazing definition, is really important to look at because it's one of the most detailed and most robust out there. So the New Jersey law also can increase, you can serve up to 5 years in jail as the maximum penalty for hazing that involves serious bodily injury or death. And depending on the severity of injury, there's other instances in which hazing can be a felony. New Jersey also has a very good safe harbor provision. I'm gonna call out a couple points of that particular provision, that if that an individual and organization can be immune from prosecution if they call 911, provide the names of the folks involved, are the first responder to the emergency, and remain at the scene while the person in distress receives help. So that's something that's really important to us. We want those good actors to be, those good Samaritans to be encouraged to call for help when somebody needs it. And the law also has some detailed policy provisions about education requirements from the school and transparency requirements. So I really encourage you to take a look more closely at the New Jersey law, because it adopts the AHC's model legislation almost in full. And then today, before I turn it over to Danny, some of our conversation really falls into what we consider to be two buckets, and these bills in pending states, some of which have died out, some of which have become the law in the state. They really fall into two buckets, and increasingly we're seeing states take these up separately. Some states have done it all at once, like New Jersey, but those two buckets are really around criminality. So the potential criminal sanction that an organization or an individual can receive if convicted of hazing. In that criminality bucket also includes safe harbor provisions. But then the other side, and we've seen some standalone bills in the last couple of years, and we're going to talk about those today, that are really more policy provisions. And when I say that, I mean reporting requirements for organizations, transparency requirements for schools and organizations. That means you have to potentially post something online, some sort of report online about findings of responsibility for hazing. And then educational requirements, especially for institutions, but also for organizations. So we've seen the anti-hazing legislation kind of fall down into those two buckets: criminality and policy or transparency and reporting. So with that, I'm going to turn it over to Danny to kind of tee up some other key issues.
Thanks, Clark, and thanks everyone for joining us today. There are a couple of things I wanted to talk about as we think about challenges with these state laws, and I wanted to continue on that vein that Clark was just talking about: education, transparency, and criminal accountability. Those are the three goals of our legislation, and they're not all three showing up in every law. And for those of you on the call who are not lawyers, we are working at the state level specifically on the criminal accountability piece, because we know that that's where criminal accountability shows up, is in state laws. But we are also definitely working on the education and transparency piece. And as Clark just said, that doesn't show up in every state law, but we are trying to make some forward progress in education and transparency at the federal level. So I just wanted to pause and make sure that you all know that along with these state laws, the Anti-Hazing Coalition is working very diligently. Just over the last few days, I've been talking to elected leaders at the federal level about our two anti-hazing laws, REACH and End All Hazing, that really focus on education and transparency. And one of the reasons that we are also working on the federal level is to create some kind of consistency. That's one of the challenges that we find when states are adopting individual state laws. There is not a consistent definition of hazing across the states. The last I checked, I think that there are 47 different definitions of hazing in 47 different states. And so it's hard if you are a national organization and you are trying to provide education to your members and your chapters across the country to create different education for each one of those states. So consistency can be a challenge, and it's something that you really need to be aware of, that those definitions can be different. And they may define hazing a little bit differently, and then they might separate out misdemeanor and felony hazing slightly different in each of these state statutes as well. So that's something to be really cognizant of, and to know that we are trying to get a national or a federal definition of hazing that could be helpful in the criminal accountability piece, in the reporting piece, and in the education piece. So if we're successful there, that will, I think, be helpful to everyone. I think the other challenge that we run into is interpretation. Again, different laws in every state, and that means that we have to know the difference between the Virginia law and the Washington law and the Arizona law. But sometimes if you are working with multiple chapters on different campuses in the same state, the campus will be interpreting the law differently, campus by campus. And we'll talk a little bit about some of these later. Virginia and Washington are two that come to mind very quickly, where schools are interpreting things differently. And that makes it very, very difficult for our organizations to make sure that their local advisors are prepared to give good counsel and advice, and that they're telling their chapter members what exactly they need to do in order to be compliant, not only with the university policy, but also the state law. So a couple of things in this interpretation area to watch out for is training. Each state requires a different type of training, and in certain states, there will be differentiation between, is that in person, is that virtual training? Does that mean you have to participate in the training before you can host recruitment? Or does that mean you have to participate in the training before initiation? There's a lot of unclarity in some of the state laws about exactly the timeline and the deadline for this training to happen. So knowing that is incredibly important. And at NPC, when our organizations ask us about the laws, we're oftentimes going back to campus-based advisors and trying to figure out why the university interpreted a certain provision in a certain way. And it may come from the Fraternity Sorority Life Office. It might come from the general counsel of that university. It may come from somewhere else, that their interpretation and what their requirements are look different from another school in that same state. Reporting sometimes looks different. Is a state law or is a school requiring reporting of allegations versus reporting of violations? So that's another huge one. Is what being put on a school website? Just every allegation of hazing against every student organization that has come to their come across their desk, every single allegation, or where we kind of take a stand and try to move the legislation is that reporting just for violations after a conduct hearing has been held, and they can report out on actual violations versus just allegations. So that's another big piece. And I think we're also having lots of conversations about interpretations when it comes to where do you report out. In the state of Washington, and we'll talk about this a little bit later, the schools are taking very different interpretations of what does it mean to report on a website. So need to know, make sure that everybody really understands that not only can the laws look different from state to state, but they can also look different on that interpretation from school to school. So I think the next thing that we wanted to do is just to talk a little bit about some of the state laws. And I'm going to start with Pennsylvania. Pennsylvania was really the first new state law that we've seen kind of changed or introduced here, I would say, in the last 6 to 7 years. And And everyone, I'm sure, on the call is aware of the death of Timothy Piazza at Penn State, and the involvement of the Piazza family in really moving the needle forward on state anti-hazing laws. And the Piazzas are a very active member of the Anti-Hazing Coalition. What I want to say is the Pennsylvania law was passed prior to our coalition coming together and prior to our template language that Clark has shared really being finalized. So it's slightly different than some of the other laws that have been passed with the Anti-Hazing Coalition's involvement. What I want to say about this is that there's one piece where we have definitely taken a different point of view since it was passed. And that big piece and that big difference is the forfeiture of real property. So in the Pennsylvania law, if an organization is found guilty of hazing, or if hazing was found to have happened on a piece of real property, that property can then go through forfeiture proceedings and be turned over to the state. And that is something that is not in any other piece of anti-hazing legislation that we have been a part of passing. And there are many reasons for that. But we make sure going forward that we talk very clearly with any state legislature of the risks of forfeiture of real property, and the fact that hazing might happen somewhere where the landowner has absolutely no knowledge that this hazing was happening or have any control over that property. And we really need to find other ways to hold folks accountable, specifically people who truly participated or had actual knowledge of hazing that's happening. The other part of this law that I wanted to draw attention to is that this is the first law where we really saw application of different groups of people who could be held guilty for hazing. So not only individuals, but organizations and institutions. And this was some conversation that we had with the families, when this law was being worked on and since then. And so we bring a lot of attention that it's not just individuals, it's not just organizations, but it's also institutions who could be found guilty of hazing if they have actual knowledge that hazing is happening on their campus. Clark or Toby, anything else that you want to add about Pennsylvania?
No, I mean, I think the property forfeiture piece of Pennsylvania is what is constantly stuck out in comparison to the other states. But otherwise, I think you covered that one, Dan.
Perfect. Well, then, Toby, I'll just let you keep going and talk about Ohio.
Great. And first, let me thank Bobby and Lori, and it's an honor to be with Danny and Clark today. I see a lot of familiar faces on here, but for those of y'all who I don't know, let me just first introduce myself and my firm so that you understand the perspective that we bring to the conversation. I'm with the firm of Saul Ewing. We are an 800 team member firm with 16 offices around the country. I'm based out of our Chicago office. I actually serve as Chicago managing partner, and we have 120 team members here. And our practice, a lot of what we do is focus on defending higher education institutions and Greek letter organizations. I can also share with y'all that I say y'all, I'm from Alabama, and I'll drop a Roll Tide in every now and then. But I worked for my fraternity as both an undergrad and then while I went to law school in the evening. And so I bring that perspective to the defense work that we do. And we represent Greek letter organizations and higher education institutions, colleges and universities, when they're facing catastrophic and high exposure losses, some of which come from alleged hazing activities. In fact, some of the faces on here I know I'll see at the Stetson Higher Ed Conference next week in Florida. And so look forward to catching up and having further conversation. The reason why I wanted to talk about the Ohio law is a couple of things. Number one, I can tell you that that law is known as Collins Law. It went into effect October 7th of 2021. And we actually defended the international fraternity in that case in what was an alleged wrongful death in connection with hazing of a pledge. And as any of y'all who've dealt with litigation knows, you typically not only play it out in court, but in these days you play it out in the media sometimes. But at the same time that that was happening, you also had the third aspect, which was the legislative aspect. And so it was interesting to watch how that played out and how it ultimately then impacted not only the suit, but what's going to go forward. The goal of Collins Law is to eradicate hazing completely. And if you've ever heard Kathleen Wyatt speak, the Wyatt family doesn't have a desire to do away with the Greek letter system because they know that hazing still persists well beyond the Greek letter system. But the law is one of the most broad that we've seen enacted because it really does have the goal of fully eradicating hazing. So let me first tell you a little bit about Collins Law, and then I'm going to leave you with 6 takeaways, and I'll do it as briefly as possible. So what the law does is it expands the scope of the activities that constitute hazing to include acts to continue or reinstate membership in an organization. And I'm going to come back to that. It's not just to acts of initiation. It also imposes harsher criminal penalties on individuals and educational institutions. The law also imposes reporting requirements on staff and volunteers of fraternities or sororities who are acting in an official capacity. I think that's some interesting language there. And then finally, the law requires educational institutions to post hazing violations on their public websites. So here's my 6 takeaways. And the reason why we're focusing on this is because it is one of the most broad. And although it may not fully comply with the Anti-Hazing Coalition's template, I think you could see other states look towards the Ohio law as a way in which they may decide to go. So your first takeaway is let's talk about the definition of hazing. A person commits hazing by doing any act or coercing another to perform any act of initiation into a student organization or to continue or reinstate membership with a student organization that causes a substantial risk of mental or physical harm, including coercing another to consume drugs or alcohol. So why is this language in there about continue or even to reinstate membership? Well, I can tell you, having lived through the case, that there was a question there about whether the pledge at issue was actually a pledge at all. And that's because there had been some facts that had come to light that the pledge had actually been suspended due to criminal investigation in connection with his behavior following a party that was at the chapter annex. And so the theory of the case was that, in fact, on the night in question, the alleged acts of hazing were being performed by the pledge in hopes that, or former pledge in hopes that he would be reinstated to the pledge class, and or that he had never actually formally been depledged. And so I think that is why you see the language in there from Ohio about continue or reinstatement of membership. The second takeaway that, that I want you to have from Ohio is that there's this increased criminal penalties on individuals. Excuse me. So Ohio law previously made it a misdemeanor to recklessly participate in hazing. But now Collins law adds a new provision making it a 3rd-degree felony, a felony for anyone who's coerced consumption of alcohol or drugs that results in serious physical harm. Your third key takeaway is this. There's increased penalties on educational institutions, including staff and volunteers. So the old Ohio law previously made it a misdemeanor for educational institutions, including their administrators, their employees, or their faculty, to recklessly permit hazing. But now it is also a misdemeanor for alumni and volunteers of fraternities and sororities to recklessly permit hazing. In addition, it's now a felony to recklessly permit hazing that involves coerced consumption of drugs or alcohol that results in serious physical harm. And people always want to know, they're like, well, how does this play out in the real world? So let me give you an example. So if, for instance, you are a chapter advisor and you know that there's this ritual on, let's call it Big Little Night, which oftentimes seems to be where sometimes these situations arise. And it's called Pass the Bottle, or there's other more colorful terms that, don't screw your brother or sister, where they basically pass it around. And if you know that to be a tradition and they've told you as the chapter advisor that that's going to happen again, and you don't do anything about it, then under the Ohio law, you run the risk of criminal liability exposure. The fourth thing is these reporting requirements. So it is a misdemeanor for educational institutions and their staff, alumni, and volunteers of fraternities and sororities who are acting in an official and professional capacity to recklessly fail to immediately report hazing to local law enforcement. And Ohio is one of those states that uses the term immediately report. Now, again, people want to know, what is the actual practical application of this law in Ohio? Well, I've always used the reasonable person standard. So for instance, if you are a leadership, if your organization has a leadership consultant on campus and they walk into a room and they observe hazing, then under Ohio's law, they're probably under an obligation to immediately pick up the phone and report it to the local authorities. On the flip side, if you're an organization, whether you're an institution of higher education or a Greek letter organization, and you get a random or anonymous tip of hazing that occurred 2 years prior, then under the reasonable person standard, you're probably not, the next thing you absolutely have to do is pick up the phone and call and report it, especially if you want the opportunity to investigate the veracity of the statement. Number 5, so Ohio's anti-hazing policy also covers now on and off campus behavior. And again, that's a nuance that we haven't necessarily seen in all of the other states. And then number 6 is where we are seeing a lot is there is the public reporting requirement, and that kicked off in fall of 2022. So our current academic year, and their educational institutions must create a report of every violation, not of every report, by the way, every violation of their anti-hazing policies, and then post that report to their public websites. And then they have to include the name of the subject of the report, the date of the report, and a description of the violation. So as I said, I think you can look to see Ohio as one of the broadest and also one of the strictest, as perhaps one that as other states embark on this task, that they will look to for some as a template or some model language. Clark, let me kick it back to you to talk about Washington for a little bit.
Okay, thanks, Toby. And yeah, I'll pick up kind of where you left off, and I'll say that while it is unique, I do think that other states could potentially look to Ohio to do amendments to their existing laws or create new laws around these topics, because it's very detailed. And when you're working with when Danny and I go and we work with state legislatures, they're very happy to see the model legislation that I referenced earlier and work from that. But they also almost always their first question is, let us know what the other states are doing, and they can find it themselves. But that's I think makes it very likely that folks could look at the state of Ohio, the state of New Jersey, and where I'm going now is the state of Washington. And there's another really detailed bill. I think I mentioned to you all earlier that these laws really fall into 2 buckets: criminality and anti-hazing policy. Washington is a really good example of a bill with really detailed policy provisions. And another reason why I think folks could look at it, when you think of the state of Washington, I want you to think of 2 things, because you're not going to remember the actual text of the statute, even if I read it to you here today. But when you think of the state of Washington and hazing issues there, I want you to think of notice and disclosure. And I'll tell you what I mean. Washington has, and I'm going to drop this in the chat after, so don't worry about jotting this down. But Washington has implemented, is in the process of implementing, but now has in law some really unique notice requirements. The first one is that fraternities and sororities would be required to notify an institution before chartering, rechartering, or opening a local chapter at any institution, public or private. Secondly, that fraternities and sororities notify the institution, and I'm going to quote from the statute here, when the organization instigates an investigation of a local chapter at the public or private institution for hazing or other activity that includes an element of hazing, such as furnishing alcohol to minors. Then the organization is required to provide the results of such investigation and a copy of the full findings report to the institution. That's a pretty detailed and unique requirement. Again, I'll drop the language into the chat here in a second, but that's why I want you to think that the law requires notice to the institution in some really pretty unique situations that you probably are not accustomed to doing. In terms of disclosure, the law requires disclosure from both ends, and what I mean by that is disclosure from the organization or the chapter and disclosure from the institution. This is another one where what's disclosed is only actual findings of responsibility, so not just allegations, but actual wrongdoing that has been confirmed through the process. And that's going to come both from the institutional angle and the organizational one, and that has a 5-year look back period. So that's pretty high level, but we want to cover some other states. When you think of hazing issues in Washington, I want you to think notice and disclosure, and then go pull the law and look at what your actual requirements are. I will before I kick it back to Toby, I will just say that as far as I'm aware, University of Washington and Washington State are still working on the implementation of these requirements with their chapters. And I checked in with some of my teammates this morning, who I see on the phone, who are working now with those schools as they work through those issues. So I haven't seen these disclosures or reports yet, but they're certainly coming, and the law is effective. And so we're gonna need to continue to monitor there. So I'm gonna go back to Toby for a little discussion on Virginia, and then I'll drop some resources in the chat.
Perfect. And Danny and I are actually going to tag team Virginia. Danny's going to first talk about the legislation, and then I'm going to talk about the VCU settlement and how I think you can see that impact civil litigation.
Yep. Thanks, Toby. And I will say the piece here that I wanted to talk about when it comes to the legislation is implementation and interpretation. It's kind of my soapbox and something that I've been paying very close attention to. But I want to say that it also applies to the state that Clark was just talking about, Washington. And we know specifically that the University of Washington and Washington State are interpreting that state law differently about the transparency piece and how they interpret the word social media. Website. And one school includes social media as to be part of the definition of reporting on a website, and the other school doesn't. So at NPC, we're trying to do some benchmarking and trying to figure out how the different schools in the state of Washington actually are interpreting that, so that we might be able to go back and lobby for a consistent interpretation at all of the schools in that state. But when we hop over to Virginia from Washington and talk about Adams Law, Adams Law is named after Adam Oakes, who lost his life to hazing at VCU. And this is a law that is focused only on policy. There was a real attempt in the legislation to hit on both policy and criminal accountability, but the state separated the two out into two different bills. One passed and the other didn't. And so each state, as they work through policy and criminality, sometimes those can be in the same law, and in other states, based on the way that their legislature works, the criminal piece has to be separated out. And so that's something that happened here. And what I really wanted to bring to your attention, again, is interpretation of the law. This is the only law that we have seen that kind of rises in my mind that requires in-person hazing education. So most of the other states require some type of education, but it is not as specific as it is in Adams Law. And so as a university starts to consider how they're going to comply and provide in-person education, particularly to individuals who want to join student organizations, they think about that differently. And that's what we have to know as leader of our organizations with multiple chapters across the state of Virginia. How is each school interpreting that requirement for in-person education prior to becoming a member? Is it prior to participating in recruitment? Is it prior to becoming an initiated member? And for this kind of first year of implementation for those individuals who are already members, how do they apply that to your chapters to make sure that chapters are in compliance? It has been different for each school that we have worked with across the state of Virginia, and they are communicating to each organization to say whether or not a chapter is compliant and can participate in recruitment. But we have seen certain schools in the state of Virginia tell chapters that they can't participate until their membership is fully educated. And so we even have one school that told us that because of the implementation of Adam's Law, that they were going to have to change the timing of recruitment on that campus because they didn't have the staffing to be able to do the education for the entire school and our community in advance of when we would normally host a recruitment on campus. So again, very, it's very important for you not only to be familiar with the law in the states where you have chapters, but how is each school interpreting and implementing. We are seeing schools take some of their policy on the hazing education and put it into their recognition agreements. Sometimes that is helpful to better understand how a university is interpreting the law, but sometimes it's catching us by surprise with their interpretations because they are differing, and our organizations are having to play catch up at the last minute to try to meet a timeline that the school has put in that might be different from the school just down the street. So Toby, do you want to talk about litigation in Virginia?
Sure. So, some of y'all may have seen the news that broke a couple of weeks ago that there's been a civil suit now filed against the fraternity that Mr. Oaks was pledging. But prior to that, you probably also saw the news break that the university had reached a settlement with the Oaks family or the estate of Adam Oaks prior to the end of the year. And it made news on a couple of fronts. First, because the university agreed to settle for just under $1 million with the estate. But what I think is interesting and what Danny touched on, and again, I always think like, what's the real life application? So you have the legislative component, what passes and what doesn't. And sometimes when things don't pass that families want, they go other avenues. And so here, there were a lot of what I'll call the non-monetary components to a settlement that if you've ever gone through the process, are real. And what I do wonder is, and I don't know who the counsel was for the university, but whether or not they actually fully understood some of what was being agreed to, and whether or not that in fact changes the landscape in Virginia. I don't think it does, because I don't think that one institution agreeing to one settlement with one family otherwise changes years of established civil law legislation or even criminal law. But what I thought that y'all might be interested in hearing are the non-monetary components of the settlement. And I boiled it down to just a couple. One is as we've seen this at other institutions, students are required to successfully complete 12 credit hours at VCU, among other eligibility requirements before they can join a fraternity or sorority. Alcohol will be prohibited at any fraternity sorority activity that is being attended by new members. That's sort of standard. They've also picked a day, February 27th, which is actually this upcoming Monday, that will be designated as Annual Hazing Prevention Day in remembrance of Adam Oaks and the circumstances surrounding his death. Again, we've seen other institutions do something like that. Here's where it gets into a little bit more. That, one of the things they say is alcohol served or consumed at events associated with student organizations shall be provided by a licensed third-party vendor and require the advance notification of VCU. Again, that's not necessarily foreign to this to this group. They've agreed to create a physical memorial to him on campus. They went ahead and codified the law that Danny was just talking about, bystander intervention. and hazing prevention will be required. They would have put in that into their settlement, regardless of whether or not it was actually going to be a legislative component. And then they've also sought to put some responsibilities on the national organizations should they continue to have a presence there. And that's where I think sometimes you don't, you meaning the collective, you don't necessarily think about the ways in which this may impact other institutions. You know, I'll just tell you as a civil defense attorney, I don't think that a settlement between a public institution and an estate in one state vastly changes the law as it pertains to other public or private institutions in the same state, unless the legislature is willing to actually act upon that and or it becomes precedent. But what I do think you always have to look at, whether you're dealing with a civil or criminal statute, is what becomes the standard that the other institutions are responsible for. And so here, at least now, you have one higher education institution as part of a settlement that has said, we're willing to take these steps. And we're willing to seek to try to impose these responsibilities on other organizations, whether we lawfully can or not. But then does that become the standard that which the next higher education institution is similarly held to? Or what are they seeking to put on the national organizations? Does that become the standard that other national Greek letter organizations should be living up to? And I think those are questions in the wake of this settlement that we'll continue to see play out in courts of law. I see. With that, we're going to go back out west to Arizona and Dan.
Thanks, Toby. Just a little quick nugget here about Arizona. Again, Arizona is not a state that the Anti-Hazing Coalition worked in to pass legislation similar to where we started with Pennsylvania. This is not based on the template language that we put forth. And actually, it kind of caught us by surprise. You know, Clark and I are working with the coalition on a weekly basis, monitoring state legislatures across the country of where laws are passing, who's introduced it. Sometimes it's because the family, one of these families who've lost a son, you know, has a good friend in another state who's willing to take our legislation forward. But what I want you to know about the Arizona law is that they added a new offense called hazing planning or organization. So this is new. I think of it as almost like accessory to hazing. It's those individuals, and it's a misdemeanor, not a felony, but for persons who commit hazing planning or organization, and they define it a couple of different ways: performing any step in a course of conduct plan to bring forth hazing. So you don't have to be there during the actual hazing, but if you participated perhaps in calling the meeting or calling new members together, and then other people came to that meeting and conducted the hazing activity, you could be found guilty of this hazing planning or organization. Engaging in conduct that is intended to aid another person to commit hazing, and the other person does commit the hazing. That's that kind of accessory to. You're helping the person who physically engages in hazing. You're helping them to be in a place where they can do that hazing. So we don't know if this particular type of language, this planning or accessory to hazing language, will get picked up in other states going forward, or if some of the states that have already passed these types of laws will add to their laws in the future to add in this misdemeanor on planning and organization. But it is something to be aware of, particularly in the state of Arizona. And if we learn that other schools or if other states are picking it up, it's definitely something that we will be spending some time talking to organizations about more fully. Clark. Oh, I think we were going back to Toby. I'm sorry.
No, that's all right. Again, I think from just real life practicality. So we've talked about, you know, Pennsylvania, Ohio, Washington, Virginia, Arizona as some of the states. But what are we seeing by way of local authorities and how they're using these statutes? So I wanted to briefly touch on the news last year out of New Hampshire, where we saw almost 50 undergraduate young men be charged with misdemeanor hazing. Now, what most of the news stories don't show is that, in fact, there was a grand jury that had been impaneled, but no felony charges came out of it. But instead, we saw, at one point there was a headline: 46 young men, all individually charged with hazing. So what actually happened there? So these were students at the University of New Hampshire, and in the spring of 2022, a video surfaced of what was viewed to be a talent show of sorts by one of the fraternity chapters there, and quite candidly, the video showed folks drinking alcohol, and there was some physical violence, and so when asked why they decided to pursue charges, I'll tell you that the Durham police deputy said this: it would be what I think any layperson out there would consider hazing if they watched the entire video. Now, no one was hurt from the incident, but you had a prosecutor that went ahead and charged nearly 50, and arrests were made. And when asked by that, she said the fist fighting and the hazing and the chugging of alcohol was what really motivated them to prosecute. Now, here's what I thought was interesting from a real life practical standpoint. The prosecution realized that they had issues with their case. And so all of the individuals were offered to do community service instead of facing misdemeanor fines or charges. And all but 3 accepted because it would then be wiped from the record, and all they had to do was community service. But 3 said, no, we're going to take this to trial. And they went to trial in December. And I will tell you that they prevailed. And what the defense's strategy was they said to the court, this was a bunch of young men in Durham amusing themselves by doing sort of silly behaviors. To pretend it was something more than that, though, I think is wrong. And in acquitting the 3 members, the judge wrote in her opinion that the state didn't prove beyond a reasonable doubt that attendance at the talent show or participation in it was a condition of membership. Incidentally, this was one of the organizations that had done away with a pledge program. So there was no delineation between pledges or new members. Everybody did it. And what the prosecution said afterwards in being interviewed was, quote, I think the judge was looking for more like, quote, we were told we had to do this or we couldn't be in the fraternity. But at the end of the day, the court ruled that the prosecution hadn't met its burden. Again, that was out of New Hampshire. But I think in educating your students and your members, the notion that we will continue to see vast numbers of individuals prosecuted, I think will only increase. And I think that's part of what the model legislation is promoting. And quite candidly, what most of the organizations who are on here is that they've adopted zero tolerance hazing policies. And so I think more and more, not only are we going to see vast numbers of misdemeanor charges, but in the states that provide it, it's not a stretch to think that you're going to see more felony charges and perhaps even felony convictions. And I think that's the real wake up call for all of the member organizations. All right. So now with that, Clark, where are we going from here? What's our state outlook look like?
Yeah, it's great. Danny mentioned earlier that Pennsylvania kind of started this round of latest changes to state anti-hazing laws about 6 or 7 years ago, and there's about 12 states that have done some work in the last 6 or 7 years, either implementing a new law or changing an old one. I think that could easily double in the next 5 years till we reach about half the states, and so. If we're about half the states 5 years from now, I think most of and this is obviously a guess, but I think that most of the states will have touched their anti-hazing laws in some way over the next 5 to 10 years. Unfortunately, many states choose to amend or adopt a new law following some sort of incident or tragedy. I think it's interesting that but based on my research, one of the 4 states without an anti-hazing statute is the state of New Mexico. And New Mexico has been in the headlines, as you know, recently, where the New Mexico State University men's basketball team has had their season canceled and been suspended following allegations of hazing. So, that's a prime candidate to get an anti-hazing law of some sort pretty shortly. That said, we have seen some states take up these changes proactively, and I think and hope that you'll see some more of that. And I think these changes are what you can expect from these is, I think the increased criminality is almost a given. You're gonna see that all over the place. If hazing includes a bodily injury, especially a serious bodily injury, that conduct can be a felony. So I think it's almost a given that you're going to see increased criminal penalties available in many states. Secondly, I think we can all expect that transparency, notice, disclosure requirements, sometimes that are very detailed, sometimes that are a bit complicated and confusing, unfortunately, I think you can expect to see those pop up more and more. So more of the ones like I was talking about in Washington, or Danny talked about Virginia, Toby talked about Ohio. You can expect to see more of those laws because people, the prevailing sentiment is people want more information from these organizations and from institutions about these organizations. And that's not just fraternities and sororities necessarily. I think it's all student organizations and athletic teams. So I think that's where we're heading. And then, we just kind of want to close by giving you some general advice in our last few minutes, and then we can answer any questions, as many as we have time for. But if you were to leave here from me with one thing today, from me, is that there really is no shortcut to understanding the law that's applicable to your chapters in a given state. So other than 4 states, all the other ones have anti-hazing laws. It's really important that you understand the differences between them. You don't have to memorize them. You don't even have to read them all at once. But as you're dealing with an issue in one state, you need to have a resource handy. I'll tell you, I look at stophazing.org a lot because they have a handy 50-state map. And just make sure I understand the law of the state that I'm working in at the time. There really is no shortcut for that. And I know how they understand how they affect your chapters. That's how I want to leave it. And Danny, Toby, anything else you guys have, and then we'll take some questions.
I think my one big takeaway is that each of our organizations has some responsibility to not only educate our members, our collegiate members, but also our volunteers. And I think that is a huge part of moving this work forward to eliminate hazing. It's educating the current students who have to know more about bystander intervention and just making good choices about what they're doing on our campuses, but also our alums, so that they understand the coaching and counseling that they need to be giving to the students, and also the responsibilities that they carry in particular states when they are volunteer chapter advisors. So I think that education piece is particularly important, even in the states that haven't passed an education requirement. It's really on us to do a better job of educating our collegiate members and our alumni members.
Because I'm an attorney at a law firm, I can never be brief. So I'll give you 2 takeaways instead of the one that Clark and Danny were both so good to offer. I think the first one is if you see something, say something. Especially if you're a Greek letter organization and you're trying to navigate these 50 different laws, and it's hard to know what to say to one state or another. I think the across the board, if you see something, you say something. If you've been in Chicago the last couple of years, there's been that ad on our trains and whatnot as we combat instances of terrorism. And so I think that's your first one. And then I would say second one, though, just because you may be an institution of higher education and you're situated in Florida or Ohio, and so you're like, oh, I know what the laws are here. don't let yourself off the hook, because we've seen in some of these cases where then the group travels and perhaps something takes place in a neighboring state. And so just because you think you know what your reporting obligations are for your home state, if you learn of it, you may be on the hook for some reporting obligations in your neighboring state. Those would be my two takeaways.
We've got a few questions popping in, so I'm going to throw these at you. What are the 3 states that don't currently have anti-hazing laws?
3 other, I think. Let's just take a quick look. So New Mexico, Montana, Wyoming, South Dakota.
Very good. And because we're higher education people, I love this question. Is there any sort of assessment of these laws and their effectiveness of achieving intended outcomes? Have any states committed to any sort of revision process based on the assessment?
I have not heard of that. Danny, have you?
Yeah, I haven't heard of an assessment, but I will say that Louisiana was one of the first states that passed a new law kind of in this iteration. The Max Groover law passed after Max Groover died at LSU, and they updated their law after about a year. So they took the feedback. The Groover family was instrumental in getting that law passed. And they heard from the Groovers, who had heard from others. They heard from us that the way that they had written their reporting requirement was actually causing folks some anxiety about what they had to report and when they had to report it and who they had to report it to. As I understand it, the local sheriff's departments were getting inundated with reporting of activity that they actually did not consider to be hazing. So the legislature took another swing at the definition and the reporting requirements, made a few modifications so that folks felt better about what they were actually responsible for doing, both as reporters and then the sheriff's office into responding to those reports. So we have seen some growth and development based on feedback coming on these laws.
I'll give you another little one, just real briefly. I know this is a bit unique, but Toby mentioned earlier how the state of Ohio's law is very detailed. They have the state Department of Education in Ohio has been tasked with a handful of professionals of working with schools and implementing that law. And so I do believe there is going to be some assessment of the law through that state Department of Education. It would be interesting to see if that took hold elsewhere. I haven't really heard of that elsewhere, but Ohio would be a place to look for that. And I think it's very possible it could, be the case elsewhere as well, Lori.
All right, this is an important question, Toby. I'm going to let you field this one. In the mandatory reporting states, the national organization secures an attorney for an investigation. Does attorney-client privilege take precedent over the law?
No.
Good answer.
No. You can still have your investigation cloaked under privilege if you choose to have either your in-house or you retain a firm. Then you can choose what to do with that privilege, but it doesn't otherwise overcome or obviate the need that you have to report.
Also, just think of it like this: the need to report is a legal requirement before you ever retain your attorney. So one comes earlier in time than the other. So a student may already have that obligation before anybody at headquarters retains an attorney. I hope that makes sense.
Yep. And I think the other structure for some of our clients is their conduct process is not done at the local chapter. It's done at a grand chapter level or at district levels. But I would, in answering that educationally, the need to report would still come at that chapter level, regardless of who's doing their conduct process. Is that how you would interpret that?
Yeah, the need to report doesn't care about the levels of your organization. The need to report attaches to the person who has the knowledge, whether it's done at the chapter level or the national level. That's not something that the law contemplates.
Yeah, it's really more about the individual reporting.
Correct.
Most reporting will come from individuals, not from organizations.
Yeah, that's the same also for colleges and universities, simply because they may have a student conduct proceeding. These local laws don't say, well, great, you get to adjudicate it first. And then if you find that there was a hazing violation, you then report it. Clark's right. It's the other way around.
Good. Okay, helpful. I'm going to tell you how great Toby, Danny, and Clark are. They have what I call the one-pager summary for each state. They've done this for their NIC and NPC clients, but they have agreed to share that with all of you who have attended today. We're not going to throw that on the website, obviously, but we are going to send that to you after they have agreed graciously to send that. And they will cut to the chase, kind of the one-pagers. At Holmes Murphy, we're going to keep looking at laws and strategies and the hazing references. Our external resources on hazing. You will see things as we continue to add, as we find little nuggets. And also I posted in here, Clark and I sat together many years ago, I think with Mark Timmy's in a restaurant, when the Louisiana law had just passed. And at that time, Holmes Murphy decided, without knowing what was happening, we were like, well, let's just model our hazing template language after the Louisiana and Pennsylvania law, because we assumed more laws were coming. So when you see the Holmes Murphy, for our Holmes Murphy client, our risk management template, it is in line with the model that we are trying to push up at the federal level. So get used to that, because now I'm more inspired that is the right way to go with how we recommend policy language. We do not dictate your policy. So Danny, Toby, Clark, please make sure you look at the chat, because people are saying kudos and thank you. Thanks for getting our brains thinking. Thank you for the conversation, and we'll be following up with resources after the event.
Thank you.
Just one last reminder on those resources. They are dated. So we have updated those resources over time. So if you get one, please always be double checking that we may have more recent versions of those based on things that we've learned, particularly about interpretation of the law at particular states, because that, again, my soapbox and always wanting to try to keep folks up to date with the most current information.
Perfect. Yes. Thank you very much. Good clarification.
Thanks, Danny.
Thanks, everyone. Appreciate it.
Thanks,
Thanks, Lori and Bobby. Bye-bye.
Thank you.